late Friday evening, after a district court judge had enjoined the Trump administration's attempt to literally cancel the law firm Perkins Coie, finding that the executive order targeting the firm was obviously and unconstitutionally retaliatory in nature, the Trump administration decided to double down by lashing out at another law firm. And this time it was, at least in part, because the firm seems to have done some civil rights work. So on Friday, the president signed an executive order called, quote, addressing risks from Paul Weiss. So Paul Weiss is a New York law firm.
And we should note, by way of disclosure, that Melissa's husband is a lawyer at the law firm.
So this executive order, like the last, was broad, it was punitive, it directed federal agencies to suspend security clearances held by lawyers at Paul Weiss. It required federal contractors to disclose whether they do business with Paul Weiss and directed agencies to review all contracts with Paul Weiss. It also, once again, directed agencies, quote, to the extent permitted by law, to, quote, provide guidance limiting official access from federal government buildings to employees of Paul Weiss when such access would threaten national security, which, again, a district court had just found was likely unconstitutional with respect to a firm with a different name, and so is also unconstitutional with respect to this firm.
Right. Like, the law does not permit this, and the statement of purpose in the executive order made clear, once again, this is all about retaliation. You know, the primary offense Paul Weiss seems to have committed is hiring Mark Pomerantz, who worked in the Manhattan DA's office and apparently encouraged the Manhattan DA to bring charges against Trump. Charges, we should say, Trump was convicted on. And the order also highlights that it is punishing the firm for, as Kate said, doing civil rights work. It accuses the firm of attempting to hire a diverse array of employees. It also singles out an instance where, quote, a Paul Weiss partner brought a pro bono suit against individuals alleged to have participated in the events, of January 6th on behalf of the DC Attorney General, end quote. Listeners, what was that lawsuit? It was a suit against the Proud Boys for defacing a black church. Thought these guys really cared about religion?
Some people's religion, Leah.
Exactly. So after we recorded, the president announced on Truth Social, and the New York Times reported, that the president agreed to rescind the executive order targeting Paul Weiss in exchange for complete and total surrender. According to Trump's Truth Social statement, Paul Weiss agreed to acknowledge wrongdoing by Mark Pomerantz, the former partner, and agreed to represent pro bono clients from across the ideological spectrum. Trump also said the firm agreed to donate $40 million in pro bono work to causes that Trump supports, including the president's task force to combat anti-Semitism, as well as other mutually agreed upon projects. That amount of money seems to correspond to something like more than 100 Paul Weiss lawyers giving a shit ton of annual pro bono time to Trumpism over the next several years. It's unclear exactly what the firm will do. It's unclear what they exactly agreed to or will agree to do, because the agreement that Paul Weiss shared internally with lawyers at the firm does not match what Trump described in some respects. And it's unclear how much of this, like pro bono work supporting veterans, for example, the firm was already doing. But this still feels like yet another failed institutional stress test. Paul Weiss is a very prominent firm that has for years been associated with rule of law causes. A Paul Weiss partner successfully litigated United States versus Windsor, the case that invalidated a key provision of the Defense of Marriage Act. Another partner helped to successfully litigate the case against the neo-Nazis in Charlottesville, Virginia, in the wake of the Unite the Right rally in 2017. There are many current and former partners who have been prominent figures in Democratic administrations and politics. Arthur Lyman, who served as president of the Legal Aid Society, among other things, was a partner. And the firm was originally named, in part, for Lloyd Garrison, a descendant of the abolitionist William Lloyd Garrison, and the man who hired Pauli Murray as an associate at Paul Weiss, and who also represented Robert fucking Oppenheimer when the physicist was targeted for his work in opposition to nuclear weapons. Basically, the executive order was unconstitutional garbage aimed at targeting the firm for its work on progressive causes. Paul Weiss could have challenged it in court, and I at least think they would have won on any number of grounds. And in doing so, Paul Weiss could have set the stage for other law firms to stand up for the rule of law. But instead, what we got was capitulation and genuflection. I should make clear that I have no idea what it is like to run a large law firm and to have the livelihoods of thousands of people, from partners to mailroom workers, in your hands. I'm sure the pressure is enormous, but law firms are not like other businesses. When we join this profession, we agree to uphold the Constitution. And this is not that. What this is very bad. When parties capitulate like this, they are, in important respects, legitimating what the administration is doing and their abusive assertions of authority and illegal overreach. And Paul Weiss was not the only institution to bend the knee this past week. The Wall Street Journal reported that Columbia University reached an agreement with the president so as not to lose the $400 million in funds that the president had threatened to freeze. Under this agreement, according to the Wall Street Journal, Columbia agreed to ban masks, to empower 36 campus police officers with, quote, new powers to arrest students, and to appoint a senior vice provost with broad authority to oversee the Department of Middle East, South Asian, and African Studies, as well as a Center for Palestine Studies, end quote. And the Wall Street Journal describes this new vice provost position is apparently going to review curriculum and non-tenure faculty hiring and leadership, quote, to ensure the educational offerings are comprehensive and balanced, end quote. Giving control over what universities teach and research and who they hire dismantles the independence of academia. It is fascist control over what people are allowed to learn, to hear, to teach, to study, and to know. In case it wasn't already clear, institutions are not going to save us. Chuck Schumer isn't going to save us. It is on us, like people. We need to be out there in the streets building our own networks. And we wanted to take this moment to acknowledge at least one lawyer who is not backing down. Last episode, Kate and Melissa mentioned the letter on behalf of big law associates that urged law firms to stand up against Trump's threats. In light of the news about Paul Weiss, an associate at a major law firm, Skadden Arps, gave their 2 weeks notice at the firm, conditioned on the law firm doing something. The associate, Rachel Cohen's letter, is worth reading in full. I'll just note a few passages. It says, for example, quote, "We do not have time. It is now or it is never. The firm has been given time and opportunity to do the right thing. Thus far, we have not. Colleagues, if you question if it is as bad as you think it is 10 times worse." And it ends with this, quote, "Like any self-important adolescent, I spent most of my high school history classes wondering what I would do in the moments before true horror or chaos or where my values were tested and demanded great sacrifice. I do not wonder anymore. I know who I am. I thought I knew who we all were," end quote. Thank you, Rachel, for your bravery. And if listeners have leads on how to help Rachel with her job search, please feel free to offer them. One outlet, if you're looking for something to do, I just want to remind our listeners of, is the upcoming race for Wisconsin Supreme Court Justice. Really the first major test of Elon Musk's ability to buy and raise another part of government. So, needless to say, last week had some sad, dispiriting days, and the day of Paul Weiss's capitulation was somehow made even worse by a letter Attorney General Pamela Jo Bondi issued together with Russ Vought. And this letter pertained to the executive order targeting Perkins Coie and the judicial decision that had restrained the administration from implementing parts of that executive order. Attorney General Bondi's letter, and written together with Russ Vought, said the following, quote, "The executive branch's position is that the executive order 14230 is permissible and that the court's order was erroneous. The government reserves the right to take all necessary and legal action in response to the dishonest and dangerous conduct of Perkins Coie as set forth in Executive Order 14230, end quote. That seems to kind of dangle the prospect of noncompliance pretty explicitly in this letter. And that is not all the administration had to say about law firms this last week.
Just because the hits keep coming, another development in around the same time is that the EEOC sent letters, right? So these are not the executive orders, but the Equal Employment Opportunity Commission has sent letters to a number of law firms, including Perkins Coie, but also a bunch of others, Latham, Kirkland, Sidley. So these are ostensibly also about DEI, but these are demand letters in which the firms are ordered to produce a truly deranged quantity of information about their activities. So some of them are fellowships that these firms have maintained, but also the letters demand information about every summer associate and even applications for summer associates for years and years and years, including names, email addresses, race, GPA for everyone who has applied for these things for many, many years. It's really interesting. This administration is forcing everyone to think and write a lot about race for an administration that really seems committed to the idea that at least certain kinds of considerations of race are deeply problematic. But of course, it's only some. Yeah, so as Karen Vladek, who founded a legal recruiting firm called Rise Point Search Partners, noted on Blue Sky, 88% of major U.S. law firm partners are white, nearly 75% are men, more than 50% of firms report having 0 black partners. The numbers are even worse when you look at equity partners. And what these letters suggest is that, any presence of black partners, maybe black lawyers at all at these firms is too much. And so they should be punished for any modest efforts they have made to try to increase diversity at their firms in light of the severe underrepresentation of minorities at these firms already. Like, it is so disgusting. Of course, that is not all. So the administration has also decided to modify the website that had acknowledged and celebrated General Charles Rogers for receiving the Medal of Honor in Vietnam. The administration appears to have deleted the page / the URL that had been used to describe this recognition, and it has replaced that URL with text that includes what? DEI medal? Like, so sadistic.
Well, in case you had any doubts about what they are using DEI to mean, this is a soldier who received the Medal of Honor, and because he's black, they are calling it a DEI medal, right? Like, the very clear implication is basically all people of color, all women, like all sexual minorities, right, are obviously unqualified and unfit for public life and any kind of presence in civic society. And, on this point, just wanted to play a clip of Sherilyn Ifill, the former president and director counsel of NAACP LDF, who appeared on CNN, Anderson Cooper's show, kind of outlining in very clear terms what is going on here.
Diversity, equity, and inclusion for your viewers is a program or a way of approaching policies really in corporate America, of hiring, of procurement, of contracts, to ensure that groups that had been formerly excluded or were underrepresented in many of the corporation's practices, employment and otherwise, would be included. And that meant casting a wider net, looking at the pools of people that you were doing business with or that you were planning to interview for jobs, and making sure that you had cast a wide enough net that you were including those who were from underrepresented groups. That's diversity, equity, and inclusion. Nothing that has been removed from these Department of Defense websites are diversity, equity, and inclusion. They are just Black people, Native American people, women, gay people, or just the word gay. So this is not an effort to remove some program that is in some way harming the military. It is, yes, an effort to whitewash history, Anderson, but I think it's even worse. It's an effort to brand. It's designed to inculcate in Americans the idea that when you see a Black person or a Native American or a gay person excelling, piloting a plane, being a CEO of a company, being a 4-star general, you should presume that they did not earn that position based on their qualifications and merits. It's a poison pill designed to reach into Americans' minds and to encourage Americans to believe that those people that they see who are from underrepresented groups, who have achieved success and who are of positions of power and authority in our country, did not earn those positions.